All right, so Jack from Missouri says there are 39 states that have that are stand your ground states. You've pointed out, I think 7 or 8 states are hard stand your ground states, and the others are soft stand your ground states. That's correct. I'll circle back at in a moment. I have the list of the hard stand your ground states. So I can share that with all of you in a moment, but let me continue with the question. So what's the difference between hard stand your ground and soft stand your ground? So first we have the distinction between stand your ground and duty to retreat. There are 11 states currently that are duty to retreat states. That number meaning you have a legal duty to retreat if safely possible before you can use deadly force in self-defense. And that number keeps dropping. So every couple of years, there's a state that falls off the duty to retreat list because it becomes a stand your ground state. I believe one of the most recent was Arkansas. Ohio became stand your ground just a couple of years ago. But in my entire career, I've never seen a state go the other way. I've never seen a stand your ground state become duty to retreat. I've only seen duty to retreat states become stand your ground. So not only is stand your ground not some exception, some weird Florida thing, it's the norm among American states, and increasingly becoming the norm to the point where right now there's 39 stand your ground states. Only 11 states impose a legal duty to retreat before you can defend yourself. But among those 39 states, most of them, 39 stand your ground states, most of them are what I call soft stand your ground states. In a soft stand your ground state, a prosecutor cannot argue to a jury that you had a legal duty to retreat and you violated that legal duty, and therefore you should lose self-defense. Hold on a second. So to be clear, when we're talking about things like stand your ground and duty to retreat, we're talking about the element of avoidance. Avoidance is one of the 5 elements, up to 5 elements of a claim of self-defense, and it has to do with whether or not there's a legal duty to retreat. So stand your ground states are attempting to take the element of avoidance out of this list of 5 elements, in which case you'd only have 4 elements that you would need to justify your use of force in self-defense. By the way, if you'd like a copy of this cheat sheet, you can get it at lawofselfdefense.com/elements. It's free. It's just a PDF download, folks. So lawofselfdefense.com/elements lists the 5 elements of self-defense, provides a brief description of each. So what stand your ground effectively does is remove a target of attack. Each of these 5 elements is a target of attack for a prosecutor on your claim of self-defense. If he can disprove any one of these beyond a reasonable doubt, you have no legal defense of self-defense. So when a prosecutor is looking at that investigative report about your use of force, he's looking for a vulnerable element, any one of them that he believes he can disprove beyond a reasonable doubt. If he can do that, your claim of self-defense collapses. And it's an easy conviction at that point, because when you argue self-defense in the first place, you're not saying it wasn't you, someone else shot that guy. You're saying it was you. I did it. I shot that guy, but with the legal defense of self-defense. If the second half of that sentence goes away, self-defense goes away, all that's left is basically a confession. Of course, a prosecutor would know this. So when we take avoidance away because of stand your ground, we're taking away one of the 5 potential targets for attack by a prosecutor. Now there's 4 targets of attack, the other 4 elements. In most stand your ground states, the soft stand your ground states, a prosecutor is not allowed to argue that you had a legal duty to retreat and you violated that legal duty, because you don't have a legal duty to retreat in a stand your ground state. What they can argue in the soft stand your ground states is that, sure, ladies and gentlemen of the jury, there's no legal duty to retreat in our state. We're a proud stand your ground state. But safe retreat was possible on the facts of this case, and a reasonable person would have safely retreated rather than kill another human being. And therefore, this defendant's failure to safely retreat made his conduct unreasonable. Well, reasonableness is another one of those elements. It's one of the remaining 4 elements of self-defense, even in stand your ground states. So this is kind of a backway argument to attack your failure to safely retreat through the element of reasonableness when the element of avoidance is no longer available because stand your ground has taken it away. Most stand your ground states, the prosecutor is allowed to make that argument. In fact, they made it in the Dean Cummings prosecution just last week, this past week in New Mexico. New Mexico is a stand your ground state, but the prosecutor was allowed to argue to the jury that, hey, he didn't have a legal duty to retreat, but the door was right there. He could have retreated. A reasonable person would have retreated. This case is all about reasonableness, ladies and gentlemen of the jury, and therefore you should fail this defendant, Dean Cummings, on his failure of reasonableness. And if he doesn't have reasonableness, that's a required element of self-defense. He loses self-defense. The prosecutor made that argument in closing to the jury, and they were allowed to do that because New Mexico is a soft stand your ground state. There are a few states, a few of the stand your ground states are hard stand your ground states. In a hard stand your ground state, the prosecution is not allowed. Well, let me rephrase that. The finder of fact, typically the juror, is not allowed to even consider the possibility of retreat in evaluating the reasonableness of the use of force. So in the hard stand your ground states, the question of retreat is completely taken off the table, because if the jury is not allowed to consider it, well, then the prosecution is not allowed to argue it. You're not allowed to make arguments to a jury that the jury is not allowed to consider. And for those who may be curious, the hard stand your ground states currently are Colorado, Louisiana, Mississippi, Ohio, Texas, Utah, Washington, and kind of Wisconsin. So Wisconsin is a hard stand your ground state if you're in a castle situation. So you're defending yourself while you're in your home. But if you're defending yourself out on the street outside of your home, then it's a soft stand your ground state, Wisconsin. So that's it. And he asked the question from Missouri, and as Missouri actually is not hard. So he goes. So Jack is saying, is Missouri a hard stand your ground state or soft? He says, I presume it's soft because the attorney from Missouri in a case said she could not have shot him if he'd been. Don't trust what attorneys say. You cannot presume that because someone's an attorney, even a prosecutor, that they necessarily actually know what the use of force law is in their own state. You'd think they would, and maybe they do, but you can't count on it just because they have that job title. Missouri is a soft stand your ground state, so the prosecutor can make that argument. Sure, there's no legal duty to retreat, but he could have, and a reasonable person would have, and therefore the failure to retreat is unreasonable. And therefore, because the conduct was unreasonable, you should deny the defendant self-defense.